Well, good evening, everyone. My name is Anna Donovan. I'm the director of the UCL Centre for Ethics and Law, and I'm delighted to welcome you all this evening to a very special conversation with our distinguished guest of honour, Lady Arden of Heswall. For those who don't know, the Centre exists to foster discussion, research and insight into issues at the intersection of ethics and law. And corporate law is, and no doubt will remain, one such issue, presenting the questions and challenges that raise considerations of justice, certainty and efficiency, to name but a few. It is against that objective that the Centre is honoured to host this evening's discussion, exploring Lady Arden's transformative impact on company law. A discussion that also provides an opportunity to reflect on the principles that should underpin a fair, effective and efficient framework of company law. So this evening I have the pleasure of introducing tonight's chair, Professor John Lowry. John will then do the honour of formally introducing Lady Arden. Professor John Lowry is an emeritus professor of law here at UCL Faculty of Laws and a leading expert in company law, having taught both in the UK and around the world, and practiced as a corporate litigator in Canada. As many of you no doubt know, John has published widely in domestic and international law journals on a wide range of company law issues, and he sits on the editorial board of a number of company law journals. No stranger to the Law Commission himself, John has acted as a consultant to the Law Commission and been cited by the Law Commission, the Scottish Law Commission and the Law Reform Commission Ireland. John, having written a soon-to-be-published article celebrating Lady Arden's career, will be leading the conversation this evening, and very many thanks to you, John, for doing so. As I mentioned, John will formally introduce Lady Arden, and thus let me simply extend our sincere thanks to Lady Arden for joining us this evening. We are all very much looking forward to the discussion and very grateful for your time tonight. A few housekeeping matters before we get started. The depth of discussion this evening means that there won't be a Q&A at the end. However, thank you so much to those of you who submitted questions before the event. John has kindly incorporated those into tonight's discussion where possible. Also, we do have a reception afterwards, so please do join us for drinks after tonight's conversation. So without further ado, I am delighted to pass over to Professor John Lowry and Lady Arden of Heswall for what will be, I am sure, a most interesting and insightful discussion. Thank you very much. Thank you, John.
Thank you very much, Anna, and welcome to Lady Arden. I want to explain how I'm going to approach this. It's not easy speaking with a living, about a living dynamic judge. Yeah. Lord Mansfield would have been far easier in many ways to dissect. The other challenge for me with Lady Arden is the fact that we're talking about a judge who has multi-dimensional qualities. Lady Arden isn't just the stereotypical judge. She's a law reformer. She's a trial judge, an appellate judge, and an author, and an active author. I happened to speak to someone at King's College the other day, and she said, oh yes, we've just received something from Mary Arden, which is referring her students to in the King's College Law Journal. Yes, so I fall over you, Lady Arden, in my day-to-day dealings. I'm not going to give a formal breakdown of what I referred to as a multi-dimensional quality that Lady Arden's career has, but I'm going to unpick it a little bit to give you a sort of landscape. And then on top of that landscape, this is the theory, I'll try and superimpose Lady Arden as a law reformer and sort of unpick the peculiar qualities that Lady Arden brought to that role. Lady Arden as a judge, but generally as an appeal judge, and that reflects the questions we've received tonight. There's certain key cases that recur in the questions, so we will be sort of explaining to Lady Arden what I think her approach was, and then Lady Arden has the opportunity to say, you're completely wrong, John. We'll also just delve in just briefly into Lady Arden as the author of scholarly articles and books. Time won't allow for a big sort of excursion into that particular facet. But we will look at one volume of the 2-volume set you published in 2015. So starting off, I suppose, just looking at what I see as you as someone that has overcome barriers. You were the first woman High Court judge to be assigned to the Chancery Division in 1993. In 1993, I was around then. In fact, we're not dissimilar in age. The Chancery Division was a bastion of masculinity, and a sort of institution of the High Court that Charles Dickens would have recognised from 150 years prior. So you really broke down or demolished that barrier. You were the first woman to chair the Law Commission of England and Wales, and that's where we first met, back in 1995, I think, 96. But stepping back a moment from that, I said it will unravel gradually. Following university, namely Cambridge, where you graduated with a star first, and Harvard, where you were awarded a prestigious Kennedy Scholarship, you were called to the bar in 1971, and you joined Erskine Chambers. You practiced principally as a company lawyer, talking about masculine bastions of masculinity. You became a QC, a Queen's Counsel, in 1986. 5 years later, you became Attorney General, the Duchy of Lancaster. 2005, you became Judge in Charge, Head of International Judicial Relations for England and Wales, and that's a project I know that you hold very dear. 2011, you became a member of the Permanent Court of Arbitration in The Hague and an ad hoc judge of the European Court of Human Rights. Now, that's quite a formidable list. It puts my career in perspective. And it really lies, I suppose, or it really means that I have to adopt a pretty narrow focus tonight and look really at your exceptional contribution to company law reform and to the continuing evolution of company law as an outstanding judge in the field. Now, looking at your many judgments, we will be getting to particular aspects, but I'm painting my landscape, remember. And when I get to superimpose particular aspects, I'll let you know, because you'll probably miss it, unless I tell you. But looking at your approach to judging, to be crude about it, they really are looking at your pronouncements. They are exemplars of what carefully crafted judicial pronouncements should be. Forensic in approach, always. Clear and accessible, always. And I think this really marks you out, Lady Arden, you have, or you continue to have an explicit recognition of the place of legal theory in company law, and you say legal theory frames the core foundations of the subject. You've long advocated the importance of law and economics, It informed the approach of the Law Commission towards reforming company law, as I'll come back to. It informs your judgments. And that is really quite significant because you explained in your judgments the importance of law and economics in the realms of company law long before UK policymakers, UK law schools recognised law and economics. So with your permission, Lady Arden, and I know from the questions that I've received and has forwarded to me from the audience, and if you forgive my tautology, I'm going to start at the beginning. Okay, you grew up in Liverpool, a place I hold very fond place in my heart. Your grandfather was a partner in the firm of Gammon Arden Solicitors, now Hill Dickinson, which a lot of people will be familiar with. And your grandfather was followed by your father and your brother. So was reading law at Girton College, Cambridge, a rite of passage for you, or had you secretly sort of harboured thoughts of doing something different from that?
Just to correct one point, if I may, but thank you very much for that kind introduction. What happened when my brother retired is that he merged into Hill Dickinson and stayed with them for a while. But my father and grandfather were both in their own firm. And so there was a legal background, yes, and it goes back further than that. But it wasn't assumed I would become a lawyer. I was at school, at a very good school in Liverpool, but there wasn't much in the way of career guidance past secretarial and physiotherapy. It was a woman-only school. But I really thought it would be good to be a doctor. There, I loved science, and the idea of getting into medical science really appealed. But alas, the maths weren't good enough, and there weren't any real depth in the science labs, so I ultimately decided I'd go up to read law, having studied classics, which I still think is a very good thing to do.
Thank you, and thanks for that correction. I'll change the proofs when they come through. You were taught company law by the late Ken Pollock at Cambridge, a colleague renowned for his rigour, a colleague who gave emphasis to the place of policy in framing the law. You were taught at Harvard securities law by who is understood as being the architect of the subject, Professor Loss. So would you say that Ken Pollock, with his emphasis on social and policy considerations, and Professor Loss at Harvard, really framed your approach towards law reform and judging?
Well, I'm not sure I would limit it to those two. First of all, I think the career, the education you get before your career starts at university is absolutely critical. You've really got to infuse it and embrace it and enjoy the wealth of learning that's going to be at your fingertips. So I think it's really important to take advantage of being at university. And there were very many teachers of law, both in Cambridge, where I studied, and in Harvard, whom I would regard as fundamental influences. But let me just mention one, because I'm not sure it's come across your desk, but it sort of broadens the conversation a bit and might be of interest to a Centre of Law and Ethics. And that was Professor Lon Fuller. Now, this may not be a name known to you, well, it might be known to some of you, but he's a very eminent professor of jurisprudence. And he was in his final years of teaching at Harvard when I was there. And I had never done jurisprudence throughout my 4 years at Cambridge. So I thought it was time I did some. Well, his was quite a different approach. First of all, I remember him physically extremely well. He was a thin, athletic man sitting on what looked like a kitchen chair in the middle of this large seminar room. and he smoked continuously. So it was as if it was joss sticks all around him, and the effect of this was that everything he said was noted very carefully and came with that flavour of somebody who never had looked at his notes. He just spoke, and the words swirled round him like the smoke. But his theory in particular that I found very interesting was his approach to soft law. And he is really the first person in the jurisprudence field, I think, who really thought about soft law. That is something which is not actually positive law. It's not law laid down by Parliament. It's not law laid down by the judges. It's actually how people every day act. So it could be customary law, or it could be guidance that was given to them and which they observe, much like the highway code used to be. So what it opened up in my way of thinking was that law is really multi-layered. It's not just about the statutes we learn about, although in company law there's a lot of statute law, or it's not even about the cases. It's looking at law as a much bigger subject. It's about behaviour, the way we act, why we act. And I think that had a profound influence. It comes back to your point. I hope I'm not taking too long about this. But because he opened my eyes to that thinking, it then became apparent to me that the way people react in response to a rule of law is something that really matters. And so, and I'm sure you'll come on to this, when we looked at directors' duties in the steering group of the Company Law Review, we came up against this problem. That when directors breach their duty of loyalty and take what we call a corporate opportunity, they see something is possible in the company's line of business and they don't offer it to the company, they take it themselves. If you have a rule which says they can't take corporate opportunities without being liable to account unless they have the consent of the company in general meeting, it means that very often the good directors will say, well, I can't take that up. We're certainly not going to trouble with a general meeting. So that just goes by the wayside. And so that part of the economy suffers because nobody takes up the corporate opportunity. They were the right people to do it. So in the Companies Act 2006, you'll find that there is a special provision which says that when you get to the duty of not to have conflicts of interest, you can take up a corporate opportunity if your fellow directors by an independent majority approve. And that was a change in the law because it was a response to the rule as it was laid down, which was developed without the context of looking at it in the wider context of how do people behave. They don't want general meetings with shareholders, and also in the context of people turning down opportunities and that being a detriment to the authority, to the economy. And that was a really law and economics point. So, but the broader point behind that is looking at law in context. There are many different types of law. We're not just concerned with statutes. We're not just concerned with the words of a case. We look at it in context.
I'll be coming back to some of those points.
Fine.
And certainly your approach in Sequana and looking at the law in context. So I will come back and statutory interpretation.
Right.
So I'm going to reel back a bit, if I may. I'm not a fisher. I don't go and fish, but you know what I mean. This not quite Liverpool, but post-Cambridge and Harvard, applying for pupillage now, judging by the number of references I write, is a daunting task. Okay? Applying for pupillage in the late 1960s, early 1970s was certainly daunting, a very formidable task. You could have chosen the easy path, following your family, your grandfather, your father. Why did you opt for that the most difficult of choices?
Why did I opt?
Why? Yeah.
All right. Well, just before I get there, I did actually do notarial articles, so I had a bit of a chance to see inside the life of a practicing lawyer, and I did it in Liverpool. And I must just tell you, Liverpool has a fine legal history. And one of the things we then had was the Liverpool Court of Passage. I just want to tell people that civil justice, it wasn't always that we were bereft of ideas. the Liverpool Court of Passage had been there for hundreds of years. You went up a winding staircase and presented your form. And there was then a strict time case management of that case because it was, Liverpool being a port, for cases against seamen who were about to go off again. So the timetable was abbreviated.
Yeah.
You got your writ filed, and the defence had to be in within 7 days, and you could get a hearing very quickly. So I did my notarial articles, that's where I came from, and I did them in Liverpool, and I went to Cambridge after doing that, and then I had 4 years in Cambridge, and at the very last term, I realised that the judges have a much more interesting job at the end of the day in deciding what the law should be. Now, obviously, they have to apply the doctrine of precedent, but there are a number of situations in which even they have a certain amount of contribution to make. Clearly, in fact-finding, that's a very privileged and important job. It's a difficult job, and I admire the High Court judges who do it, and the county court judges. At an appellate level, you're then thinking about where the law should go, which is, assuming, as it often happens, you meet a complete gap in the law. You come where the cases stop. Your case is not like the last case, and so you've got to decide which way to go. So that's why I went to the bar, and I joined an Inn of Court. I joined Gray's Inn at that point.
Right. So you're at Erskine Chambers now, in my thing, and you get the occasional instruction to prepare an opinion, and you don't sign your name on your opinions at that point, you initial them. I probably can guess the reason why. Remember, we're in the early 1970s. Why did you do that?
Well, then the solicitor wouldn't have the embarrassment to have to say, well, actually, it's a woman who wrote this opinion. I have to just give a little bit of background that in Lincoln's Inn at that time, there weren't very many women. I can only recall well one woman practicing barrister, and she smoked a Sherlock Holmes pipe. Now, she was very nice but and very well established, but that just shows you there weren't very many women around, and so I just thought solicitors might value not having to tell their solicitors their clients.
It's a little different now, I presume.
It is very different.
Yeah.
That's then. Now is an entirely different story, and you must all come to the bar if you fancy doing that.
Time marches. I could sit here for many hours. I want to now jump way ahead a little bit. I'm skipping you as a trial judge, although I must say I enjoyed your trial judge judgments on section, or the unfair prejudice section very much. You really framed that. So I'm jumping now to law reform, and but just before we get to the Law Commission, I'm stepping back a bit. As a barrister in the early career stage, if you like, you joined the, or should I say, did you have an interest in law reform as a young barrister? Did you participate in any law reform process at that stage?
Yes, I did. And you've stopped because you just read, no doubt, that was the Law Society's Company Law Committee that I joined. Yeah. And you're thinking, well, how can a barrister have done that? Have I got this wrong? The answer is, you didn't get it wrong because they had some co-opted bar members, and I was made one of those.
You got good eyesight.
No, I can't see. I'm just making that up.
Because I'm squinting on my notes. Okay, so it was an interesting time to jumping now into the Law Commission, and you've cut your teeth with the City of London Law Society. Interesting time, the Law Commission, as you joined it, and it may not be a coincidence, but in 1998, if my memory serves me right, the Blair government announced the Company Law Review. And the President of the Board of Trade and who else was it? Oh yes, the Lord Chancellor asked the Law Commission to look into two areas of company law, and this is where we met. Okay, the first one is shareholder remedies, and the second one, directors' duties. And we'll focus a little bit in a minute on your particular approach, or the Law Commission's particular approach to those two subjects. Did your experience with the City of London Law Society help you in the role?
It was extremely good background, but the actual prompt for the shareholder remedies project, we're coming on to that, was that when I was at Harvard, you had to do a thesis. So having been quite stunned by what people like Ralph Nader was doing as a minority shareholder activist, I decided to do a paper comparing US and English law, and that meant that I did a paper on Foss and Harbottle, which anybody who studied company law will know is the most extraordinary rule which restricts shareholder actions. They could not understand this in Harvard. Why you should want to stop shareholders making directors accountable. So it was an interesting time to do the project, and thus when I actually became chair of the Law Commission and we had the opportunity to do shareholder remedies, I got my thesis out again.
Right.
See, another value of a good intellectual and academic career.
Soon after you joined the Law Commission, you're called upon to write an annual report.
Oh, yes.
So you sort of bridged between, was it Mr. Justice Brooke, who was chair, and then you came in, and I found your forward to that annual report very interesting. It gave some insights into your thinking. You say, and I'm quoting, we have directed efforts towards increasing our contact with government, and you go on to say that it is hoped that greater priority will be given by the government towards implementing our law reform recommendations. So I sense some frustration there.
Well, this is one of the myths of law reform, is that we have a large number of reports covered by dust. It's almost as mythical as thinking that the Chancery Bar in the 1970s was like John Dennis and John Rez, had moved on since then, and Charles Dickens. But the fact is that 70% of the recommendations of the Law Commission ultimately get adopted. It just takes time for government, the wheels of government, to turn, to find an appropriate space to put that Law Commission report into action, which generally means taking a bill through Parliament. And it usually connects up with other law reform that they're doing. So, for instance, in company law, we spoke about them having a blood bank of ideas, and then they would ultimately have one of their mega companies bills, which they did in 2006, but the ideas had to wait till then.
Yeah. In fact, the 2006 Act, I think it still is the longest statute in the history of...
I don't know whether it still is, but it certainly was when it was presented, when it was in Parliament.
Yeah. We'll look at your decisions shortly on where I detect economic efficiency is a driver in your thinking. So we'll come back to that or look at it. You've written scholarly articles on economic efficiency and the law. I'm quite interested in the Law Commission's adoption of that. The project on directors' duties, the Law Commission's, I don't want to say it was you, it's the Law Commission, right? But I like to think it's probably you. Appoint Professors Deakin and Hughes to undertake an empirical study that feeds in very much to the proposals on directors' duties. The idea of an economically efficient regime underpins that joint report of the Law Commission. And this brings me back to an earlier question. Is it your experience both in jurisprudence and with Professors Loss and Ken Pollock that was driving the thinking, your direction or your input into this project at the Law Commission? Or were there other factors at play that you'd learned as a trial judge, as a practitioner?
Right. Well, I think one thing, if I could just touch on in relation to that, one thing people may not remember was that there had for 120 years been reports by official bodies saying directors' duties ought not to be a matter simply to be found in case law. It should be set out in the statute. And there were about 5 commissions or royal commissions which said this. And the answer always was, from the practicing legal profession, no, 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 you can't consolidate fiduciary duties. You'll ossify them and then they won't be effective. So that was the first battle to get over. That actually we had to prove that directors in companies actually wanted a statement of duties. And so Professor Deakin and Alan Hughes did a survey of directors for us, and they found that 9 out of 10 directors would have wanted a statement of duties. Now, at this point in time, law reform is becoming much more evidence-based. So the government were looking for evidence, and this was really critical in getting through a statutory statement of duties. There were all sorts of problems about how you did it to preserve the flexibility of the common law, of the equitable principles rather, but you had to get over the position of the legal profession. It's very interesting. We've just also been looking at the consolidation of the 1925 Law of Property Acts. Some of you may be familiar with those. And that was also law reform driven by lawyers. And the fact is that all it did was take the previous law and put it in place in these very complex statutes. But it didn't try to simplify land law. And this is a problem about the legal profession. We're so busy trying to apply the law, we don't always see that there are issues about does it need to be modernised, does it need to be kept up to date? So, and all I'm saying is in relation to directors' duties and the statutory statement, which was a real breakthrough, Alan Hughes and Simon Deakin together produced the evidence that enabled us to persuade government about that.
That is quite an undertaking, and we're going to have a look now then at how this statement of directors' duties has sort of been operating in the courts, principally your court. Right. So moving to your judicial career, there's some questions from the audience here that I've sort of incorporated. I'm going to distill from your judgments what I detect as common threads. You may well disagree. I've chosen 2 Court of Appeal judgments and 1 UK Supreme Court judgments. As I say, well, I chose, members of this audience did. The first judgment I want to look at is Murad, right? Goes back to 2005. I then want to look at Item Software and Facetiae, decided the year before. And then your final published judgment as a UK Supreme Court judge will look at Sequana. And what I thought I would do, because not everyone will be up to recalling these cases immediately. So I'm going to just sort of outline each case and then try and distill from you, Lady Arden, how you've harnessed the various factors that have, shaped you as a reformer and shaped you as a judge, and corporate legal theory, really. So, in relation to your approach towards economic efficiency, it's quite obvious to me that stands centred stage in your judgments on directors' duties. And Murad, which is a decision on ill-gotten gains by a director, disgorgement, really, of secret profits. In Murad, economic efficiency flows through your approach in that, but also you give prominence to achieving a principle-based approach, both in the application of the law and its development. And so you're very happy to apply a case decided over 300 years ago as the orthodoxy, Keach and Sanford. But what I enjoy, without being sycophantic, Lady Arden, is having looked at Keach and Sanford, 300 odd years old, you then look at it through the lens of a 21st century judge, which is somewhat different to perhaps 20 or 30 years ago. So looking at Murad and the orthodoxy, if you like, of Keach and Sanford, and looking at it through the modern lens, what's your objective in Murad? Is it the continued development of the law, the need to maintain efficiency and legal certainty? Because I detect an anxiety in your judgments to maintain legal certainty, not to do violence to the law. So taking long-settled principles, they should be, perhaps in your thinking, viewed pragmatically for the needs of the modern age. Would you say that is a fair assessment of your approach in Murad?
Well, I think the assessment is for you as the reader, but I will say this, that first job of the judge is always to apply the law. And Keach and Sanford had stood for very many years. All I was saying was the principle is quite sensible because it means that fiduciaries, whom often the beneficiaries cannot supervise, are liable on a deterrent basis. They're liable to disgorge profits and not just the loss. And I'm glad to say that that also appealed to the current Supreme Court in a case called Rukadzi very recently, affirming the principle. It also, I have no problems with looking back in time at cases, because legal history is like any other form of history. The further back you look, the further forward you can see. You see it as a continuum. And that was the rule that was established 300 years ago, as you put it. And therefore, there is continuity, and directors know full well that that's the consequence of the fiduciary duty.
Yeah.
And in the statement of directors' duties, in the Companies Act 2006, there's a clear differentiation between fiduciary duties and common law duties of care. And that's deliberate to make sure that the fiduciary principle continues.
Yeah. We'll come back to the point you made about legal history shortly, because I also detect in another case you're a fan of Lord Mansfield. So we'll come back to that and the importance of settled law. And so Murad, there was a finding of bad faith, which was crucial, really, and you recognised the value of prophylaxis as a policy objective of fiduciary duties. And I guess sort of linking this question with one earlier that I posed, let me put it very simply, do you see the inexorable application of settled legal principles as an impediment to law development for the future? Or do you see it as a stepping stone for incremental development of the law?
How very interesting to put it that way. I mean, as I repeat, if I may, that it's my duty to apply the law. But then, as I mentioned, the law very often runs out because you've got decided cases to look at and study. But there's not usually, very often there is not, one exactly on point. So you then have to use your legal judgment as to whether or not that case is to be distinguished or whether your result falls into precisely the same set of facts. And that is a question of looking at the law, obviously, but also the context.
I mean, there's a passage in your judgment in Murad, which I won't read out word for word, but you do look at this aged principle of fiduciary liability, and you make the point that there may come a time for a higher court to revisit the inflexibility of the old rule with a view to sort of mitigating its harshness. Am I correct?
You are correct, but
Yes.
then the third member of the court was an extremely eminent member of the Court of Appeal who was dissenting, so I was sort of nodding my head in his direction.
Right, okay, yeah. Just asking you, there's another question from the audience, really. I add a gloss to, probably, to its detriment. Were you conscious, or are you conscious, as an appeals judge, that you've got to maintain cohesion because you have a constituency, and the constituency are the practitioners in this room, and beyond, the litigants, but also future trial judges. Were you conscious of that in framing your work?
You can't always produce certainty. The judgment should be clear to the best of your ability, but and you must obviously consider the question of certainty, but you may not always reach it.
Yes. Well, as an avid reader of judgments, I can say you're absolutely right. Judges don't always reach that. They don't always reach your clarity, though, either. Coming to another question from the audience, there must be an essay or question on this. It's in Murad, and it relates to causation. Much vexed issue of causation, and it's I pulled my hair out over the years. So I think the way you proceed is on the basis of certainty is the objective, and the context in Murad is whether a wrong-based approach towards fiduciary liability or a disability-based approach towards fiduciary liability should change the causation rules. And of course, academics, trust, equity, academics have debated that over the ages throughout the Anglo-Commonwealth, and as have judges debated that. You go straight to the core of the issue and you decide that basically the same causation rule should apply, because it would be clearly unfair if a fiduciary is liable for all profits that fiduciary makes from whatever source. So you said, but of course there has to be causation, and absent causation, no liability to account. Now that's a certain rule, legal certainty, clarity. So would you say that one of the problems with, say, causation, which I do find so complex, with piecemeal development is that piecemeal, and this is perhaps the common law, big jurisprudential question here, perhaps the common law is a real impediment to achieving the legal certainty that has driven you in many of your judgments, this piecemeal development. So you take causation and you have several tests emerging, which does little to help.
But that's the advantage of the common law, is that you move step by step. And so you can see how it works out, and you can trim it in the next case when you need to trim it. I think it's a very good way of deciding cases, taking, as I think one American writer puts it, one case at a time. I think you're probably thinking of those cases about asbestosis.
Yeah, well, that's a great illustration of the problems with causation. Yeah.
But in the field we're talking about, fiduciary duty, what happens is the fiduciary who makes a profit, which is a secret profit, has to disgorge it, and it's up to him to show he didn't make a profit. And there's a discretionary, a safety valve, because the court's got a discretion to say, well, although you made a secret profit, you put in a lot of labour yourself, and therefore we're going to award you this amount of remuneration or something like that. And in Phipps and Boardman, the leading case, the allowance was extremely generous to the trustee.
Yes. Gosh, time. Faceti, if I can come to item
Yes.
software and Faceti, that generated, there's a corporate opportunity case in the way that Lady Arden explained, a director sort of intervening in the maturing opportunity and usurps it, takes it. Before it gets to the company, the director takes it for him or herself. Rather crude explanation, but I guess it would do. Now, one of the things that several things strike me about Faceti, and I really welcomed your judgment. The first thing that struck me about your judgment, and it's not the only judgment where you do this, you willingly look at the scholarship in other jurisdictions to see how the law has developed. Not all judges, even now, but certainly not before you in a way, was so willing to look at academic commentaries and to look at other jurisdictions to solve a problem here, to see how they have come up with solutions. What prompted you in a way to be willing to look at scholarship in the US? Was it your time at Harvard? Or was there some
It
greater
may have been
thing?
cited by counsel. I can't recall.
Right.
But you have to be very careful about looking at other authorities and bringing them into your judgment, because clearly you can't rely on a foreign authority unless the parties have had a chance to deal with it. If you say it's dispositive of the issue and they haven't had a chance to argue it, that would be unfair. So if you ask counsel, will they address argument on this point? They do it very diligently, but it ups the costs for the client. So you have to be really careful about doing this, and you can't do it in every case. But it does, as you put it, sometimes show you that you can do a better job if you know what they've done.
Yes.
And deal with it that way. It happens to be an interest of mine, but I try to keep it well within bounds.
The other sort of facet, really, about your judgment in Faceti is how so many academics got it wrong. They misunderstand you, and some Australian judges. But my take, and I draw this from your own words, is that you were looking at the duty of loyalty that's owed by directors, and you were adding some content to that duty, and that part of loyalty means you disclose your wrongdoing, all right? Some academic commentators, not me, Lady Arden, would say that, or they have said, and some Australians have said, you've come up with a super-added duty of disclosure. That's not right, is it?
Well, obviously the case decides what it decides, but if you ask me about that issue, you have to just give one more fact to the audience, and that is that this director was claiming severance. He'd been dismissed because of this, and he was saying, I didn't breach any duty, so you pay me for breach of my contract in full. And the question was whether he'd committed a breach of duty. So it's against that context that you've got to consider this question. The significance that I would have attached to it from the judgment is the fact that it's folded into the duty of loyalty, because by this time Parliament had enacted that there was a duty of loyalty. It had not enacted there was a duty of a sort of more vociferous kind with lots of emanations. It was one principal duty, and therefore it was important to consider that point, and I think important that the conclusion was that it was part of the fiduciary duty of loyalty.
And I think in the way in which you frame your judgment, you anticipate, well, this is how, it's like reading a religious text, you sort of superimpose your own views, but I like to think you were anticipating academic criticism because you kind of answer it, that this is not a superadded duty of disclosure, this is in fact part and parcel of a duty. If you're loyal, this is what you do. And if you're disloyal, you don't, right? Loyal people will disclose wrongdoings. Yes?
Yes, loyalty means selflessness.
Yes.
So you act in the best interest of the company, not for any collateral purpose. And when the company is being asked to pay a large sum of money as severance, what's in the best interest of the company?
Yeah. Right. And I'm always amazed at how you remember the facts of the cases
No,
you
not
said.
necessarily.
I have such difficulty remembering cases, you know, ask any students in the class of mine, you know. I think, well, God, I can't remember that. I should call you in, Lady Arden.
No, please don't take me too literally.
Time really is marching on, and I do want to get to Sequana because it holds a symbolic significance for me. It's the last reported case in the UK Supreme Court, and it's a massive case in terms of significance to both company lawyers and insolvency practitioners. Notwithstanding time, the pressure of time, and I don't want to sort of rush through Sequana to the point of obscuring the significance of it. The majority appear to accept that there is a, use shorthand here as one of the justices did, there is a creditor duty subject to certain conditions.
A duty in relation to creditors,
Yes.
not owed to creditors.
Is it Lord, who's in the case? Is it Lord Briggs?
Mm-hmm.
He uses a shorthand.
He does,
yeah.
but I think it's important just so the audience realises we weren't saying that companies owe duties to creditors.
Yeah, and you certainly didn't because you were in the minority. So you have the majority in Sequana sort of saying, well, this duty in relation to creditors, right, will trigger where directors know or ought to know that the company is insolvent or bordering on insolvency. Whereas Lady Arden in the minority is much more nuanced and is probably right, in my view. Because you say, well, the interests of creditors can only supplant the interests of shareholders, and I'm reading from your judgment, when the company becomes irreversibly insolvent, making insolvent liquidation unavoidable. So those sort of words, for me, represent the hallmark of your approach towards judging, if you like. It's a very nuanced judgment. And you subject this duty in relation to creditors to, in a very sort of forensic examination. Maybe because you're a member of the Company Law Review Steering Group. So you start off with basics. Let's look at the statutory interpretation. What did Parliament say? Parliament did not give content to this duty of loyalty, right? So we cannot therefore superimpose on those words some sort of creditor duty. You then seem to be mindful of the significance of this decision for future constituencies, judges, litigants, practitioners. So you strive for legal principle, clarity, legal certainty. You look again at North American jurisprudence.
Mm-hmm. We weren't helped on that occasion.
No. Well, that says, or North American jurisprudence rejects the notion of any such duty.
Let creditors look after themselves. That's their philosophy.
Yeah. But basically, the other aspect, and I must rush, otherwise I'll keep you here beyond anything that's time that's reasonable. I think you mentioned Lord Mansfield's special juries, and of course Lord Mansfield was judging 300 years ago, and he was a superb judge in as much as he was the architect of a lot of commercial law, and he admitted he didn't know a lot about commercial practices. So he would bring in experts to make up a sort of jury, and they would guide Lord Mansfield in formulating the principle. And you expressed a certain support or interest in that way of judging, which I thought, well, that goes back to your pragmatism in terms of looking at settled legal principle, but recognising, as Lord Mansfield does, that settled legal principle must result in justice for the constituencies it serves. So, would you say then, and then we'll leave Sequana, and I'll finish with your authorship. Would you say that Sequana was the opportunity for you to really sum up your judicial approach towards developing the law?
No. I just want to be clear that it is also possible, not just that I had been thinking about my Harvard education, but also if you sit practicing company law in Lincoln's Inn, you very often find yourself in a room with directors who are saying, we think we're solvent. If we get that contract, we're solvent, but we don't know whether we're going to get it. So if you put a test, I think this is a practical point you've got to bear in mind when you look at Sequana. If you put the test as originally suggested, that there's simply a realistic chance of the company being wound up, you put directors into an impossible position. What do? They know they've got a problem. It may be just a cash flow problem. It may be they just don't know whether they're going to get the contract. Their judgment is that they will, but they don't know for certain. So it's sort of it's difficult to impose on those directors a duty that they've got to take into account the interests of creditors when they don't know whether creditors are going to be interested at the end of the day or not. So this question of when does the duty arise is extremely important to directors in the field. And Lord Reid and I put it as really at the last conceivable point, which is irreversibility of liquidation. And that's an important distinction. For when I've looked at the legal commentary, what it's done is it says, well, you've got these options. Either it's a remote chance of insolvency, or it's a realistic chance, or it's when you've got insolvent, or when the liquidation is irreversible. And it's open to the law to pick any of those examples. But that's just the point I was trying to make about looking at law in context. If you have to decide as a judge what the rule is, you should be looking at the practical consequences, in my approach, not just at the fact you've got 4 legal options. You've got to think about how it's going to work in practice. And certainly there was a lot more to be argued in the case because it came up on very restricted issues. To my mind, there was also the question of what insolvency actually meant. Do we apply traditional cash flow or balance sheet tests, or do we have some new test in this context, which is more realistic to the type of situation that directors find themselves in? And their problems may go up and down. It's not linear, the path to insolvency. One day they have a conversation with the other contracting party, which makes them optimistic. Next day they don't, so it goes up and down. And the law has to take these things into account, especially company law, which is absolutely tied up with the economy.
And that's where I see the shadow of Lord Mansfield.
Yes, of course.
Okay, my last question, and then I hope you'll come down for a drink with us. I just want to, I had a few questions, but it's going to, I owe it to you, Lady Arden, and to the audience to let you go at some point. You're an author, not just scholarly articles, but also books. I mean, you can put some academics to shame. So on top of everything else you've done, you found time to write. In 2015, you wrote a 2-volume book common law and modern society, keeping pace with change, shaping tomorrow's law, available from all good booksellers, right? And you look towards, in many ways, the future. You look towards the judges, the judiciary in the future. You raise the issue of judicial accountability. And you also stress the importance of delivering judgments in accessible language. So I'll take those in reverse order. So given the continuing evolution of the law and the complexity of modern practices, really, commercial practices, corporate practices, is the goal of accessibility achievable, do you think?
Well, I hope it is, but I think it will take time. There are ways of doing it which are fairly obvious, like having headings in judgments or list of issues, some kind of content. I was particularly keen on putting having written the judgment note, putting the conclusion at the top as well, so that the person knowing it, reading the conclusion first, knows how much he's got to read of all the rest of the material, because he then knows what issue is relevant to him. And also that focuses the mind when you write the judgment, that you're writing it and putting in matters that are relevant to the conclusion you've reached, and not going into diatribes about something which matters not to the parties or to anyone else. So I do think it's achievable. I'm very encouraged to think it might be, the chances are enhanced by AI, because
Right.
AI can do a lot of sensible rewriting. And that may help too, because judges will be able to have a go at putting it through AI and say, oh my goodness, that was what I was saying. I didn't realise I could put it quite as simply as that. And they may try to amend their judgments accordingly.
Right.
Normally, of course, we can't use AI. We have to deal with the arguments that are presented.
Yes, yeah.
But that sort of task is anything.
You also mentioned in that second volume accountability of judges. What did you have in mind in terms of accountability? Was it just the fact that they're subject to an appeal process if the litigants think they got it wrong?
Absolutely.
Yeah.
I also sat on the committee which devised the discipline regulations, so I was trying to think whether you meant accountability in other senses. Obviously, judges can go wrong not only in the judgments, they can go wrong in the courtroom as well. There's been a recent report by Harriet Harman, or headed up by her, on that regard, and there are a set of discipline regulations which apply to the judiciary.
Right. Okay, well, that really just leaves me to thank you. It's been an immense privilege spending time with you, and thank you for joining us. You know, it's not often that we get the opportunity to sit with a Supreme Court judge whose work and sort of is handed down and frames our lives in a sense, you know. And so it really has been an insightful experience to talk with you, speak with you about your approach. And as I said at the beginning, you are quite unique in the hallmark of your work has really framed modern judging and as well as law reform. And that's been very meaningful to me and I'm sure to the audience. So thank you, Lady Arden.
Thank you all for listening. Thank you.